Hi, I'm Andrew Flusche. I'm your Virginia traffic and misdemeanor defense lawyer. Let's talk today about an important trial motion called a motion to strike, about what it is and how it's helpful. Basically, a motion to strike is a motion that the defense can use at the conclusion of the Commonwealth's case. So the Commonwealth first puts on their case, called their case in chief, where they're supposed to lay out enough evidence where if the judge, or the fact finder, but in general district court it's a judge, where if the judge believes the evidence, that is enough to prove that this person standing here in court, the defendant, committed these crimes. That is enough to prove it. What the motion to strike means is it's the defense argument saying that even if the judge believes every word that was uttered, and in the light most favorable, if we kind of almost twist over backwards and say, well, let's connect the dots, and yeah, okay, if we believe everything that was said by the Commonwealth's witnesses and all the pieces of evidence, even if we believe that, a motion to strike is arguing that there still is not enough evidence for this person to be found guilty of the crime that they're accused of. Basically, they're saying that this case is junk. That's what a motion to strike means, that all the elements, all the pieces haven't been laid out. And this is without the defendant putting on any evidence to try to contradict it. It's just saying that this case is junk, there's not enough pieces to prove guilt. So if the Commonwealth leaves out an essential element, frankly, a motion to strike should be granted by the court. Because the court should say, well, here's the defense argument that this element was left out, and if it really was left out, the motion to strike should be granted. And what that means is that the case is dismissed, the defendant walks away. So it's a great motion, and obviously if it's ripe, if there's an issue to argue, the defense should make a motion to strike in most cases. Maybe there's some trial strategy why you might not want to, but it's something that I think should be considered. A good example of a motion to strike is if the Commonwealth forgets to establish venue. Venue is proving that this offense occurred in the county where it's being prosecuted. So in Spotsylvania County, for example, if we have a reckless driving ticket, the officer has to say, all these events occurred in Spotsylvania County. Seems like a technicality, but it's an important issue. It's proving that this court has the venue to hear this case, and this court can now continue and potentially convict this defendant of a crime. So if there's no word uttered about venue, or if venue's vague, like, well, I was on duty and driving down the highway and encountered this defendant. Well, okay, you were on a highway, but that doesn't tell us where it was, that it was even in Virginia. If venue's vague or not established, then the case, quite frankly, should be stricken. So that's what a motion to strike is. It's kind of the defense's first chance in the middle of the trial to argue to the judge that they've left out a piece, the Commonwealth has left out a piece, and the case should be dismissed right then and there. You can also use a motion to strike on individual charges. So if the defendant is charged with multiple things, what I would do is certainly be paying close attention to the elements and think, okay, did they get every piece they need for this part of for this ticket? Did they get the pieces they need for this ticket and for that ticket? Sometimes Commonwealth attorneys even get too focused on a more serious charge, and they might forget to trot out a little bit of elements for a less serious charge. Like if you have a high-speed reckless driving case, and the defendant also is alleged to have not been wearing his seatbelt. Sometimes the prosecutor will be focused on radar proof and the speed and all these different things, and totally forget to ask the officer, was he wearing a seatbelt or not? And if that's the case, the seatbelt charge should be stricken at a motion to strike stage. So that's a motion to strike. Hopefully that's helpful if you're representing yourself. If you do have a case in Virginia, I definitely recommend talking with an attorney. If your case is local to the Fredericksburg area, I'd be more than happy to talk with you. And if not, we can hopefully connect you up with a great referral to help you with your case. Thank you.